Good day, ladies and gentlemen, and welcome back to another What If video. My name is Viapia, and as always, it's great to have you. Today's topic is: what if an employee resigns with immediate effect pending a disciplinary hearing? Can the employer still proceed with the hearing itself? Now, we can all agree that when an employee resigns on notice, the employee may still be disciplined and even dismissed during the course of serving the notice period. Under those circumstances, the employee's dismissal would interrupt their resignation, and it is recorded that the employee was dismissed as opposed to having resigned. The question, however, is what is the legal position when an employee resigns with immediate effect? Now, practically speaking, as an employer, you may be faced with the following scenario. The employee is charged with misconduct, and when receiving the notice to attend the hearing, the employee tenders his or her resignation, which is with immediate effect. So the question is, can the employer proceed with the disciplinary hearing? Now, our labour courts have been quite split on this topic, and we have seen conflicting judgments in this regard. Some cases state, or the judgments state, that an employer may proceed even if the employee resigns with immediate effect with disciplinary action. Other judgments state that when an employee resigns with immediate effect, technically speaking, the person is no longer an employee, and therefore the employer has no jurisdiction to take disciplinary action, which obviously includes dismissal. But luckily for us, the Labour Court recently, I think back in December 2020, finally resolved the debate. And the matter I want to refer to is the Standard Bank of South Africa matter. In this case, the employee was given a notice to attend the disciplinary hearing by Standard Bank, and it was alleged that she cashed a check without following proper procedures. The cashed check was later on discovered to be fraudulent, which caused Standard Bank financial loss. On the same day that the employee received her notice to attend the hearing, she also tendered a written letter of resignation with immediate effect to her superior. Now, the superior went to consult with HR and was told that the employee was required to serve a 4-week notice period as provided for in her contract of employment. Standard Bank then proceeded with the employee's disciplinary hearing during the notice period. And at the disciplinary hearing, the employee being legally represented, she argued that her resignation, which we know was with immediate effect, terminated the employment relationship immediately, and that Standard Bank was therefore not entitled to proceed with the disciplinary hearing. Now, the chairperson of the hearing rejected her argument and proceeded with the hearing. The employee and her attorney then decided to not participate in the hearing, and the hearing then proceeded in their absence. The employee was ultimately found guilty and dismissed. Standard Bank then notified the employee of her dismissal, and when she heard that she's been dismissed, she approached the Labour Court on an urgent basis, so she lodged an urgent application seeking an order that her dismissal is to be held invalid or to be held invalid. Standard Bank, in turn, they opposed the application on the basis that the employee's letter of resignation was not valid because she had not given the required notice in terms of the notice provision provided for her in her contract of employment. So the matter was now currently before the Labour Court. The Labour Court held the following. A resignation with immediate effect terminates the employment relationship immediately, and an employer is not entitled to require an employee to serve his or her notice period. In this regard, the Labour Court then effectively declared the employee's dismissal null and void. So the Labour Court said if an employee resigns with immediate effect, the employer is not entitled to require the employee to work out the notice. In other words, you're also not entitled to take disciplinary action or hold a disciplinary hearing during a notice period where a person resigned with immediate effect. Standard Bank was not happy with this outcome, and they appealed the decision and took the matter to the Labour Appeal Court, which the Labour Appeal Court ultimately upheld the appeal. So the Labour Appeal Court said the following. If the contract provides for a notice period, as was in this case, the party, as was the employee in this case, the party that seeks to terminate the contract must give or serve the requisite notice. The court found that the employee's reliance on her resignation being with immediate effect was of no assistance to her. The court found essentially that Standard Bank was therefore within its rights to hold the employee to her notice period and to proceed with her disciplinary hearing during that period. So the Labour Appeal Court, ladies and gentlemen, therefore confirmed that a resignation with immediate effect does not terminate the employment relationship where the employee's contract of employment stipulates a notice period. So, when an employee resigns with immediate effect, notwithstanding their contractual obligation to serve a notice period, the employment relationship will terminate only at the election of the employer, who may either choose to waive the employee's obligation to serve a notice period or seek not to enforce it. Where the employer elects to enforce the rights to an employee working their contractual notice period, an employer may discipline an employee during that period, regardless of whether an employee is resigned with immediate effect or not. Also important to note that where parties have not agreed to a notice period, Section 37 of the Basic Conditions of Employment Act, which deals with notice of termination, will apply. So just to summarize, in light of the Labour Appeal Court judgment, an employee will not be able to escape the disciplinary process by tendering a resignation with immediate effect. There exists no such thing as resigning with immediate effect in the employment context unless the employer waives the notice period. Notice must be served, or it must be given in terms of the contract of employment or in terms of Section 37 of the BCA, as we said. Now that brings us to the end of this video. Thank you for joining us. We trust that you have found the content of the video useful. For any further information and advice in this regard, please do not hesitate to contact us. Until next time, bye-bye.